Thank you very much for joining Keating Chambers live webinar. I'm Holly Gavahan, Business Development Director at Keating, and I'd like to introduce today's speaker, Tom Owen. Tom was called to the bar in 2011. He regularly appears in the High Court and arbitration and has appeared in 3 remote hearings in the past few weeks. He has another this Friday and a remote trial in June. Over the next 30 minutes or so, Tom will draw on his experience to cover the practicalities, law and procedure around remote hearings. He'll follow this by responding to as many questions as we can get through before 10:45. You can submit questions by typing them in on the right-hand side of your screen during his talk. I'll hand you over to Tom.
Holly, thank you very much for that introduction and welcome everyone. Today's talk, it concerns remote hearings. We've all had to get used to a new normal over the past few weeks and the court is no different to that. The purpose of today's talk is hopefully to allay some concerns as to what's involved in remote hearings, to talk you through the process of what actually happens and to provide some practical guidance as to how best to make use of these hearings. I don't know how you feel about remote hearings, but my overarching concern before having my first one was this kind of scene, obviously very different to a courtroom, or yet worse, given that my children use this software, that this would appear and I wouldn't be able to remove it. Thankfully, none of that was the case due to preparation and very useful help from my wife, Livy, keeping the children occupied. The purpose of today's talk, as I said, is to discuss those outlines concerning remote hearings. The first aspect that we'll look at is the law and procedure, hopefully dealing with that at some pace so we can get on to the practicalities of what actually is involved before finally considering some points for discussion and also taking questions. So law and procedure, the legal landscape is very different to how it was a few weeks ago. Courts have had to get used very rapidly to adopting and using these remote hearings. There are some legal aspects we need to consider. CPR Part 39 deals with hearings. The general rule is that hearings are to be in public. That obviously creates some difficulty when we are all in different locations around the country dialing in remotely. CPR 39.22a provides that the court shall take reasonable steps to ensure that all hearings are of an open and public character, save where the hearing is held in private. Pretty much all TCC hearings are in public, and that is no different for the remote hearings. The Coronavirus Act 2020 was legislation implemented following the outbreak of the pandemic. Section 55 aims to increase public participation in court hearings to facilitate members of the public, if they wish, to dial in and join court hearings. The Coronavirus Act amends the Courts Act 2003 by providing specific provisions which enable the public to see and hear proceedings, whilst also implementing specific offences for recording or making unlawful recordings of those proceedings. So the aim and the function of that legislation is to allow greater access to justice and more people to join in if they so wish. I should say, yes, we've got what, 12 screens there. Who are we kidding? The TCC cases that we do are not going to attract huge audiences. But of course, the intent is there within the legislation. A further practice direction we need to be aware of is 51Y. That specifically deals with audio and video hearings, and it provides that where a media representative is able to access those proceedings remotely whilst they are taking place, they are automatically deemed to be public proceedings. And we'll see from an example listing, which I'll put up in a moment, that is invariably the case in TCC cases in the High Court. It also makes provisions to deal with in private hearings, but that won't be the focus of my talk today. We'll be dealing with the usual hearing in the High Court of public proceedings. So what does a listing look like? If you type in High Court cause list or TCC cause list into Google, you'll come to the official HMCTS website. it will look something like this. So at the top of the screen, you'll have the particular court that you're in, so the Business and Property Court, TCC, Queen's Bench Division. It will now state, which it didn't obviously before March of this year, remote hearing via Skype for Business. Occasionally, the TCC uses other platforms, in particular Zoom, but this is the principal vehicle used by the court for hearings. It will then say the judge's name, the date, the time, and then the type of hearing. Invariably, that will be either a trial, an application, or an adjudication enforcement. It will then have the claim number. And at the bottom, dealing with the Practice Direction 51Y point that we've just discussed, it will make provision for the media to contact listing in order to dial into these proceedings and making clear that this particular hearing is a public hearing. So that's what the listing looks like. Very briefly, Practice Direction 51ZA, not directly relevant to today's talk. It concerns extensions of time. It extends the period by which parties can agree to extend deadlines by consent from 28 days to 56 days. And it provides explicitly that the court shall take into account the impact of the pandemic. So with that legislative background in mind, let's move on to the practicalities of how these hearings actually work. And as with most things, the key is in the preparation. So let's look at how that works out. The features that I'll be looking at are the order itself that you will receive in advance of the hearing. That is much more substantial than we're otherwise used to for in-person hearings. We'll consider bundles, skeleton arguments and authorities. Again, a slightly different process and protocol there. The software and the vehicle for the hearing. There will inevitably be some concerns or questions as to whether your particular computer or software supports this hearing, whether you can join, whether your lay clients or your solicitors can join appropriately, whether you have licenses for particular software. We'll consider all of those issues. Equipment and setup. What do you actually need at home in order to do these hearings? What would be preferable or a nice to have? Attendance sheets, we'll come on to those. The test hearing, the final hearing itself. Technical hitches, yes, they do happen. We'll look through how we avoid that and how we deal with those. And finally, the giving of a judgment. So first, the order. As I said, this is a lot more detailed than we're otherwise used to for in-person hearings. The recitals are different. They take specific notice of the pandemic. There is express provision in the order that this is a public hearing, or if not, that is a private hearing under 39.23G. There are provisions concerning notification of attendance, documents, the hearing itself. This is dealt with in some detail. So the vehicle, the invitations for the hearing, the time by which you are to join, and the recording by the court of the hearing. And finally, there are reasons given for why a remote hearing has been ordered. So let's look at an example. I've drawn this up based on the experience and orders that I've had in other cases. I've obviously redacted names, claim numbers and the like. So you have the usual heading, then you have the recitals of particular note as this one, the judge taking notice of the coronavirus pandemic and the measures taken in response. You then have at the outset specifics as to the nature of the hearing. So a remote hearing, that's in bold capitals just in case you miss it. And then a specific provision saying that it's to be in public. Notification of attendance. In the usual run of things, if I were to attend an in-person hearing in the High Court, I would fill out an attendance sheet, as with my learned friend, just setting out what our names are and the name of the firm instructing us. That is a similar process now, but much more detailed, and I'll come on to what that form looks like and how you go about submitting it. Then there are detailed provisions for documents. So the parties are to cooperate in ensuring that those documents, that all documents necessary for the court are provided. Provisions for filing and serving the indexed and paginated bundles. These are at least 3 clear days before the hearing. I've seen some orders where that is much longer. So again, everything is prepared that much more in advance. Electronic bundles shall contain only documents that are essential to the remote hearing. Please note that large electronic files can be slow to transmit and unwieldy to use. There is a lot of truth in that, but I'll come on to my views as to electronic bundles and how they should be structured and the preferences of the courts. There's then specific provision for the format in which those bundles are to be presented and prepared. Invariably, they are in PDF, unless you are using a specific e-bundle or document management system such as Magnum Opus. So there will be a PDF bundle. There's then provision as to how those documents are to be sent. In all of the cases that I've done, they are sent by either a link which is created publicly or by a share platform that the solicitors have. I've not seen a USB stick used, and given the current conditions of posting and receipt of that, I would suggest it's far safer to email the judge's clerk with a link electronically, such that everyone has the documents that are required for the hearing. Skeleton arguments, no real change there, save that in my experience the order provides that they are to be filed earlier than they used to be, and similarly authorities, they are usually a little earlier as well. There's then detailed provision for how the hearing takes place. So first, the vehicle. Invariably, the order will say the hearing shall be, I've got a fly in the room, the hearing shall be Microsoft Teams, formerly known as Skype for Business. All of the orders that I've seen say that. It is in fact wrong. Whilst Microsoft Teams was subsumed within Skype as a business, and whilst the court is aiming to work towards using Teams, at the moment it doesn't have the license or the capacity, I think, to do that. So the court does use Skype for Business. So notwithstanding what is set out in the order, do check the cause list, because it will state the medium by which the hearings to take place, but it will invariably be Skype for Business. There's then provision as to invitations to join. So much like this webinar, you will receive an email, not from Holly or Marie, but from the judge's clerk, setting out the joining instructions and the particular link that you need in order to access that hearing. There is then provision, which you would never see, obviously, for an in-person hearing, stipulating that parties and counsel should attend 30 minutes before the hearing, so that any issues in terms of connection or administrative matters can be dealt with. Finally, there is a provision under the hearing as to the recording. That's done by the judge's clerk. There can be no recording, either sound or audio, by any other party or attendee. That would be a criminal offence and contempt of court. So there is a recording. Transcript requests can be made following that hearing, and there is then liberty to apply. Where there is a remote hearing which has been ordered by the court, as opposed to an in-person hearing, the court then follows that at the end with these three reasons. And again, these seem to feature in all of the orders which the court gives. I have considered the papers in this matter and can see no reason why the application cannot fairly be disposed of by way of remote hearing. States that the remote hearing is necessary and in the interest of justice, and then finally records that with remote hearings there is greater complexity, and the order seeks to anticipate those issues. So that, in a nutshell, is the order. Whereas this would have been usually in a page or a page and a half, it is now much more complete. That will be within my slides, so feel free to take that away with you. Next, bundles, skeletons and authorities. We're all used to very heavy paper bundles. Excuse me. That is, for the moment, a thing of the past. The bundles now, for counsel at least, are electronic. I've noticed in some of my hearings that if they're particularly intensive, the judge has requested hard copies of particular documents or particular volumes of the bundle, but almost always the judge operates on an electronic PDF bundle, as do the solicitors, as do counsel. PDF, that is stipulated in the order. Let's talk about some of the specifics though. The bundle size. Sometimes if it's, say, a routine adjudication enforcement, the bundle may be a lever arch or two, so 500 to 1,000 pages. That is very easily accommodated within one continuous PDF. If the bundle is of an unmanageably large size, then it may not be helpful to have 6,000 or 7,000 pages in one PDF. It may be appropriate to split those PDFs into different volumes and have different files dealing with them. The index itself, my preference, and I believe the court's preference, is to have the index included at the start of the bundle as part of the bundle itself and paginated such that the page numbers at the bottom of the page match those electronic numbers which are at the top. So when you ask the judge to turn to a particular page, say page 500, if the judge types in 500 at the top of the screen, that number will match with the pagination at the bottom. So make sure that's the case. Bookmarks and software. A key to navigating especially larger bundles is to have electronic bookmarks. Those are quite easily done within PDF Acrobat itself. I think it's essential to have some form of professional Acrobat software. I have DC Acrobat Pro. I'm not being paid to to sponsor that link, but it is a very useful tool, and it's important that you have access to them, because what I've noticed is that counsel and solicitors have to take steps themselves to insert documents into the bundle, knit them together, paginate them. You as counsel and solicitors will find that a lot easier, in my experience, if you have detailed software to do that. Document transfers. How do you actually get the documents to the other side and to the court? Most firms have their own share file platforms or similar, or you can send a public link. Usually these PDF files are too large to send as emails themselves, so you need to make sure you have procedures in place to deal with that. Skeleton arguments, much the same, other than some of the guidance in the literature, which we'll come on to at the end, suggests that these may be more detailed than they were previously. For obvious reasons, there is a concern, I think, among counsel especially, how will the court react to all of this paperwork? How will it deal with it? I should probably put in a slightly fuller skeleton. And finally, authorities. The judges invariably require a joint authorities bundle, as they would for a normal hearing. That will need to be stitched together as part of the PDF software that we were talking about earlier. So you may have 8 or 9 cases in different PDF files. You can combine those files and create a bundle separately for the authorities. Software and vehicle for the hearing. So the court refers to this as the vehicle for the hearing. As I've said, it's invariably, but not always, Skype for Business, notwithstanding that Teams is stated in the order. A Skype account is not actually required to attend the hearing. So I've had a number of solicitors ask me in the hearings we've done, do we need to have a Skype account? Our firm doesn't have a Skype license, or we use another platform. The answer is you don't need a Skype account. You'll be sent a link, just like you were for this Teams call, which allows you to join either in browser or within the app without having your own specific license or username and password. Depending on which medium you're using or which vehicle you're using, do check the video and the audio settings. Computers now have various cameras and microphones, and you can be set on the wrong setting or the wrong device. So make sure that you check out the audio and the video settings prior to the hearing. Similarly, microphone and video during the hearing. Make sure that you know how to mute your microphone and turn your camera on and off. That will become of relevance later. But again, prepare all of this in advance. If you're using Zoom, that is occasionally used. I think Mrs. Justice Jefford held a trial last week or the week before using Zoom. I don't have experience of using Zoom for hearings. As I've said, Skype for Business tends to be what the court ordinarily uses. Equipment and setup. How does that work? This is the first computer that I ever had in the mid-90s. It was a Macintosh Performer 6200. Purchased for a birthday present, I believe, by my mum and dad. I remember that very well. I don't have it still, but obviously there's something about the 90s that made them slightly ahead of the time. Who would have thought that this is what we may look like in today's world? I don't know about you. I've attended a lot of conferences with clients where people are wearing headsets and the like. I'll come on to what you need. My view is that you don't need to have a headset and a microphone of that order, but of course, whatever you feel comfortable with. It may depend on your location. If you're in a particularly loud household with lots of children and not much room, having a setup like that may assist. So what are the essentials? What do you really need? Well, first of all, and this is probably the hardest to procure, bandwidth. What I've noticed on my hearings is that on 2 occasions, counsel on the other side have struggled with buffering at their end, so their video and audio playing in real time and working as it should. I would suggest, if you can do it that you have a hardline connection to the internet rather than Wi-Fi. One way to do that is to have a link system. You can buy, mine is with TP-Link, you plug it into the wall, into a socket, into an electricity socket. You then pass a cable between your router and the socket. If your study, like mine, is in a different room, then you plug in another plug into the electrical socket in that other room, and then there's a hardline cable that goes from that socket into your computer. So it uses, or it transmits in some very clever way, the internet through your electrical system, through your sockets effectively. So you don't need to have a modem port, you can use the electrical system. A system like that, in my view, is well worth investing in. Wi-Fi, in my experience, especially when the children are doing schoolwork or there's other pressures on the network. These hearings tend to take place obviously at peak time, so 10:30 in the morning or 2 o'clock in the afternoon, just as everyone else is either working or watching Netflix. So bandwidth, very important. Webcam, you need a webcam if you're an advocate. The CPR provides that when you are cross-examining witnesses, they need to be able to see you and vice versa. Obviously, when addressing the judge, you need to have a webcam as well, so make sure you have a good one. Microphone, most webcams have microphones built into them. You can get a standalone microphone if you wish, but you need some form of microphone. And finally, as quiet a location as possible. Easier said than done. From my own experience, the court clerk will request that you try and conduct the hearing from as quiet a location as possible. It is, of course, still a court hearing and a public one, so the solemnity of the occasion should be preserved as far as possible. Also have your phone in case signal drops, but also for the purposes of taking instructions from your solicitors, which I'll come on to a little later. Preferables. What are the preferables, the nice to haves? 2 or more screens. My experience is that you will have one screen open for the courts, you'll have another screen for the bundles. You will soon be opening up other bundles, and by within 2 minutes into the hearing, the Skype pane screen where you see the judge and counsel is all but obscured. You need to have a system for dealing with that. So if you only have one screen, then split your screen in half, have the bundle on one side and the vehicle or another document on the other. But if you can, have 2 or more screens. I know some firms have policies of providing screens to their solicitors. So if you can, try and get 2 screens. And also a laptop or a tablet. If you can't get 2 screens, then perhaps have a tablet to have the bundle or at least one of the windows open that you need on that separate device. Attendance sheets. Yes, your name does have to go on the list from Dad's Army. This is what they look like. Remote hearing attendance form, case number, case name, claimant defendant, hearing date and time, party file in the document. So far, so good. And then at the bottom in grey, all persons attending on behalf of this party. You will then fill out the name of counsel or solicitor advocate appearing, the instructing solicitor's name, and any attendees from the lay client. Email, direct phone, capacity attending. Take care when filling out capacity attending. This should stipulate accurately what your position is. One judge wished the form to be resubmitted because I think one of the solicitor team had put counsel or in-house counsel, stipulate very clearly whether it's counsel, solicitor, lay client, and then speaking, that should only be ticked yes for the advocate speaking, so the solicitor advocate or the barrister. Everyone else should have no. Okay, so we've got to a position where you have the order from the court, you have the vehicle and the details by which this hearing is to take place. The provision as to documents, bundles, skeleton arguments, they've all been filed. You've filled in your attendance sheet and submitted that to the judge's clerk. The next practical point is the test hearing to check that everything is okay. This is a very important part of the process. This is organised by the judge's clerk. It is not attended by the judge. It usually takes place the last business day before the hearing. The purpose is mainly logistical, to check that the advocates can be seen and can be heard, and that everyone else can see and hear each other. The judge's clerk will explain the court's preferences, so usually this will involve things such as whether you have your microphone muted, whether you have your video off. Usually the protocol is, and this does depend on the judge, but usually the position is advocates are encouraged to have their microphones off when they're not speaking, but to keep their video on at all times, and that solicitors and lay clients are to have their microphones and videos off at all times. One of the unusual quirks about Skype for Business is that if you have, say, 10 or 12 participants on the call, lay clients, solicitors, court reporters, judges clerk, whenever a particular microphone from a particular person detects a sound, that then promotes you in the list of on the pane of who you can see. So soon, if everyone had their video on, people who shouldn't ordinarily be at the forefront will be promoted, as it were. So if you have your video off, that system of reorganization of the panes doesn't work. Similarly, if you have your microphone off, you will not be bumped up anyway. So this is a way purely of keeping focus on the judge and the advocates and ensuring that they remain within central view on the screen so that everyone can see them and hear them. The judge's clerk will then explain the process of a remote hearing and how that works, and I'll come on to the detail of what actually happens there rather than just repeating the process twice. The judge's clerk will encourage you to arrive early. The order will usually say 30 minutes before. My experience is that the clerks, notwithstanding the order, say if you come within 15 minutes before, that is fine, and provided you have a seamless or relatively seamless test hearing, that is usually the case. The court will also notify any expected additional attendees. So usually this will be court reporters. We've had Thomson Reuters on all of the hearings I've done, and I think another organisation as well. So you've done your test hearing a day or two before the final hearing with the judge's clerk. Then you have the final hearing. Nothing to be concerned about here. Again, having done the test hearing and done the preparation, this should run relatively seamlessly. My first practical tip is arrive early, dress appropriately. Obviously arrive early because that's what the order says and that's what you've been told to do. Dress appropriately. Again, this is a public court hearing, so it's important that if you are on camera, you're dressed as you would be for court. So that requires you to dress appropriately. Judge's clerk will come on, say if the hearing's at 10:30, the judge's clerk will be on there at 10:10, 10:15. He or she will check that the advocates can be seen and heard, check that the participants can see and hear the clerks and the advocates, check that all other participants are muted and have no video on, invite the judge then into the hearing. So when everyone is ready, when all the kit works, 10:29, the judge will then come into the hearing. The clerk will then call on the case, so say the case number and the case name in the usual way, and will state that this hearing is being recorded by the court clerk. There should be no other recording. It is a criminal offence and contempt of court to do so. All of this will be recorded, so the calling on of the case, the statement at the start about recording, that will all be recorded by the judge's clerk in audio and in visual. Then the judge will come on and effectively repeat that all again. So whereas in person, the judge will look to counsel for the applicant or the claimant, who will then just begin, there is a bit of a run-up in my experience. The judge will explain the process of a remote hearing to the lay clients and the solicitors. The judge will explain then technical matters such as if the connection is slow, the court may ask the advocates to turn off the video. In one of the hearings that I conducted, counsels whose children were being homeschooled at the time, and I think taking a lot of bandwidth, was really struggling with his video. It was quite intermittent, quite jumpy. The judge asked him to turn his video off, which counsel very graciously understood and agreed to, and that seemed to solve the problem. So that is usually the first port of call. If your connection is slow or not working, you may either ask or be asked to turn your video off. If the connection drops entirely, the protocol is that you seek to rejoin by video using the invitation link that you were sent, failing which you have to dial in by telephone. That hasn't happened to me so far, but it could do conceivably in the future. If you're not looking at the camera, the judge will say that if he or she is not looking at the camera, the court is still listening to the submissions. Very nice to hear, I guess. Yeah, the judge in my particular case, I think, had 4 screens, so was often looking either up here or down here or down here. The court just made that clear, I presume, for those attending to make sure that the court was was listening. Preferences: the court will state or restate its preferences of muting microphones when not speaking. Some judges don't insist on that. They openly say that you may leave your microphone on. The court will then finally ask each person attending on behalf of the party to identify themselves. So that will then begin with counsel for the claimant, who will then be followed by the solicitor, and then the lay client team, and effectively they will go round the room of those who are attending in an official capacity. The judge will not ask members of the public to identify themselves. The judge then states what e-bundles the court has open on the screen before them and what the court has read, and then states the order in which submissions are to be received, and then away they go. Counsel may remain seated, of course. That is another feature of the case. You don't have to stand up. The judge will tell you can remain seated, and then away you go. Handing up documents, how does that happen? Well, I had to do that in one of my hearings. I emailed the judge using the judge's email direct, copying in counsel for the other side. It was relatively seamless. There was a bit of a lag in terms of the email being sent and received, but no difference to the usher getting up, taking the document and handing it to the court. Witnesses: I've not had a hearing involving witnesses yet. I've got a trial coming up next month where we'll have a number of witnesses of fact for which cross-examination will be required. One hopes with good preparation that this will be sufficient, but I suspect it's a part of the process which is on many people's minds. Yes, this seems to work quite well for legal submissions and shorter hearings, but how will it play out for trials? Stenographers and e-bundle operators, they also join in the usual way. Taking instructions: how does the advocate take instructions from the instructing solicitor? How does the instructing solicitor take instructions from the lay client if you're all in different locations? That needs quite careful thought in advance. My personal preference is to set up an instant message group on your phone, which is a separate device to the screens that you are using. A problem with emails, I guess there are two problems. One, you have the loud ping of an email coming through. Two, the delay and crossover of emails means that it can be quite a cumbersome or slow way of taking instructions. I found that having a WhatsApp group or something similar is the better way of proceeding. I have a colleague who is doing a hearing who received, I think, 91 or 92 messages during the course of his submissions by WhatsApp. So obviously careful thought is needed as to who is part of that group and how those instructions are distilled and passed through. Finally, my last word of advice, I guess, on practicalities: be self-aware. In a courtroom, there will be probably 10 to 20 feet between you and the judge, a large room with windows, perhaps, lots going on. On a remote hearing, as you are looking at the screen now, there is usually just one or two or three people who are in view. They may be on full screen, so moderate your reactions. Don't make any sniggers or remarks which you would not want the court ordinarily to see, so take care with that. Technical hitches: blue screen of death. That hasn't happened to me, thankfully, so far. If the connection is slow, again, turn off the video is probably the option. We've talked about rejoining if you drop out entirely. Piece of advice: don't just talk more loudly or more quickly hoping that it's fine. Again, in one of my hearings, this is what counsel for the other side tried to do, valiantly batting on, just talking louder and louder, hoping it was fine. The judge had to intervene about 5 times before his internet buffered and caught up with him and realised there was a problem. So take care with that. It's best just to ask and make clear what the position is, because whereas you are sitting in a room by yourself, it may not be immediately obvious to you or to others what the problem is or how it is to be resolved. It's best just to take a minute and discuss that with the court. Judgment: how's that delivered in these times? Well, extempore, it's either delivered immediately after submissions or after a short adjournment, again by video, all recorded, or there is a reserve judgment which is handed down by the COVID-19 protocol, that is emailed to the parties, as well as release on bailey. So finally, a discussion where we'll open up the Q&A. This scene seems a far cry from from where we are now. I wonder how long it may be before we're all in court again together. And similarly, pupils, so the pupil with the pupil supervisor, my pupil, Thomas Saunders, who is excellent. I'd commend him to you if any instructing solicitors are watching. We've been apart since, I think, the 13th of March now. We speak regularly by FaceTime or video call, but it's not quite the same. So again, it'll be interesting to see when this all resumes. My concluding points before we take questions are, there has obviously been tremendous proactivity and industry from the court service and the TCC and court staff. Keeping these hearings moving is no mean feat, and that should be applauded. And there are indeed many positives. In smaller or lower value or simpler claims, undoubtedly, in my view, these hearings work as effectively as an in-person hearing, and no doubt reduce the administrative burden, travel time and cost of doing so. It remains to be seen, but there are concerns as to the limitations of this technology and how it works with especially live evidence. And there is obviously a question mark as to what next and what is to happen. I've put on the slides some further reading that you may find of use. So the Business and Property Court Remote Hearings Protocol, the ICCA Principles for Remote Advocacy, and the COMBAR Guide. The Lord Chief last week said that there would be no going back to the old days, and that where video technology could be used, it would be used in future. So this lovely image may be a thing of the past, but with that, that's a whistle-stop tour of my experience of remote hearings, and I'll hand back to Holly now, if I may, for questions.
Thank you very much, Tom. And thanks for the questions that you have submitted. I'm now going to ask Tom's views on some of those questions. So Tom, first question, have you found your oral advocacy approach has changed at all with the move to remote hearings?
Yes, I think I have. It's very hard, frankly, to gauge the judge or gauge the room. I'm here in this study by myself, looking directly into a camera, but basically it's like I'm talking to myself. So I guess in terms of preparation, I take that little bit more time whilst delivering the points to ensure that the court is on the right page and either of the skeleton or of the bundle, because what you don't have the advantage of is just getting on your tiptoes, looking over and seeing where the judge's pen is or where the judge's hand is. So I guess taking that little bit more time is how I've noticed my principal change.
We've had a question about taking instructions from your solicitor. You mentioned direct messaging. What do you do if you need to take instructions? What do you ask the court to do?
Yes, I personally, I'm just up front with it. I say, excuse me, my lord, my lady, may I just take instructions of that? I'll be on my phone. And the court invariably says, yes, of course, take your time. I've not had to either mute or do a telephone call in order to take instructions. I have had to ask for a little more time in order to get that, and the court has always accommodated it.
So another question which is relevant to time is, how much extra time do you think you need to allow for remote hearings? Yeah,
excellent question. I think it depends on the nature of the hearing. So with say an application which is purely legal with no evidence or cross-examination, or an adjudication enforcement which is a matter of legal submissions, the hearings can take place, in my experience, within the same time estimate as you would have had ordinarily. For witnesses, I don't have experience of that yet. I'll be discussing with my learned friend how we go about that, but I expect there will be additional time needed, because you'll have the stenographer's breaks, but also there is invariably, as we saw, 10 minutes at the start of the hearing where the judge and the judge's clerk introduce the case. There'll be a bit of time required when swearing the witness in. All of this time over the course of a day will add up. So where there are live witnesses, you have to factor in additional time.
Thanks, Tom. Have you found that, as well as technical difficulties and the e-bundles, etc., have there also been advantages to remote hearings?
Yes, I think there have been. I think the principal advantage is convenience and cost saving, frankly. I've been involved in very heavy hearings, obviously, throughout the years, where there have been large volumes of paper bundles with 2 or 3 parties on each side, leading and junior counsel, the court. All of those bundles can cost tens of thousands of pounds to produce. With an electronic bundle, it's done very quickly, almost, well, effectively for free. So there is obviously a cost saving. We are obviously a very international market, not only what we do as an industry, but also as a chambers. So having people dial in from wherever they are in the country or abroad undoubtedly saves on travel time, cost, and the like as well. So I think efficiency and cost saving, where there is modest or no lack or loss in quality of justice in terms of how the hearing presents and the access to justice, that has been, in my view, a significant advantage. I'm not saying that will be the case for every type of hearing you do, but for the ones I've done and the ones which the court routinely deals with, that is undoubtedly an advantage.
Tom, in your experience, have most remote hearings run smoothly?
Yes and no. I've had mixed experiences, to be honest. Usually on the whole quite smooth, and again that's all down to the preparation. You must spend time doing your own personal preparation with your kits, your setup, and also with the judge's clerk, and liaising with the other side. You must be cooperative with the other side. If you do that, it tends to be fine. The things which have slowed down the hearings are either bundle issues, precisely which bundle we're in, although that's very quickly solved in my experience. But secondly, the other side having technical issues, that tends to be the main slowing factor.
Next question is, any thoughts of how cross-examination of experts will go?
Yes, cross-examination generally, experts and factual witnesses, is a bit of an unanswered question in my book. It is not as satisfactory having the witness or the expert on their own in other surroundings, without the court or the court bundle necessarily around them. I suspect it will have to function as well as it can, but it will have to be also a question in every case as to whether in your particular case that can take place fairly.
Tom, do you think remote hearings can operate fairly where one party is legally represented but the other is a litigant in person?
Yeah, that also is an excellent question, and that comes down to, I think, the overarching point of access to justice and having the solemnity of going into court and having your day in court. I think provided that both parties have relative parity in terms of equipment and access to the court, so they can be seen and they can be heard, the court, I'm sure, will take extra steps to ensure that the litigant feels that they are having their full day in court. Again, it will depend on the nature and the type of the hearing, though.
I do have a further question. I'm not going to publish it, but it is asking whether you think all the participants in remote hearings are suitably dressed, or do you think some people maybe not quite as suitably dressed as others?
No, my experience is that everyone has been suitably dressed. What I've not been able to discern, though, is because when I join, my diligent solicitors have always joined ahead of me. And they've then gone on to black screen, so I don't know quite what everyone's necessarily wearing, but I'm sure it's fine.
That's good to know. I think we have reached the end of our questions and the end of our time today, so I'm going to hand back over to Tom to wrap up with any final thoughts he's got.
Okay, great. Holly, thanks for that, and thank you everyone for joining. I mean, this is obviously uncharted territory for a lot of us, and doing these hearings has made me a lot more confident about what's involved and how it's going to work. I think before I started with my first hearing, I genuinely had the concerns of the Mr. Potato Head, the kids coming in, my connection dropping. In reality, those are not real concerns, if provided you've done the preparation and you've liaised with the other side and the court. That there are obviously going to be question marks as to whether this is suitable for all cases. Given the current circumstances there, I think the courts have done a tremendous job in keeping all that it can keep moving. So if anyone has any additional questions, I'm very happy to take those by email or on LinkedIn. But once again, thank you all for joining and for taking the time out to see us today.